Okay, I think shall we kick off? Good morning, everyone, and welcome to our first employment law update of the year. Um, we've got quite a few interesting cases to discuss today, and we are also, or Talit is going to be taking us through some of the key proposed amendments to the employment laws. My name is Roz Davey, and I'll be facilitating this session today. And I'm joined by various of my colleagues from the Employment Law Practice Group. I think those of you who are regular attendees, I think you'll know everyone on the panel. But for those who don't, I'll introduce the panelists before they present. Before we begin, I'd like to run through some housekeeping matters, which will hopefully enhance the webinar experience for you. As participants, you are automatically muted and the chat function has been disabled. If you have any questions, please use the Q&A function and I will look at the questions and choose a couple to ask the panelists. We won't be able to, or we're unlikely to get through all the questions, and we won't be giving any written responses, but we'll certainly try to answer some of them during the webinar. The webinar is being recorded and a copy will be on our website at www.bowmanslaw.com, and we will also be sending out high-level summary of the cases that are discussed this morning. So with that, I'd like to introduce Talita Labsha. I think she is a very well-known face and has been doing these seminars when they were in person and now webinars for a very long time. Talita will start by just discussing the amendments, and then she's got a case dealing with unfair discrimination that she'll take us through, and then another case talking on constructive dismissals, and where she'll be considering the threshold test for intolerability in a constructive dismissal case. With no further ado, Talita, over to you.
Thanks, Raz. Good morning, everyone. It is lovely to have you on the webinar again, and I hope that 2026 is treating you well. I'm not going to go through all of the proposed amendments. Some of them are quite technical, but there are a couple that are quite far-reaching. These amendments were published on the 26th of February, and stakeholders have until the 28th of March, that's next Friday, to submit their comments and representations in respect of these proposed amendments. If you haven't yet done so, I think it's important to get a copy of the proposed amendments and to have a look and to make comments if you feel that is something that you want to do. First, the proposed amendments to the BCEA. As we discussed previously, there was the Constitutional Court case in Van Wyk that changed the parental leave regime in South Africa completely, whereas there were various forms of caregiving leave under the BCEA. In Van Wyk, the court consolidated all of those into one category, being parental leave. Importantly, it makes provision now for parents to share the 4 months and 10 days parental leave entitlement. And it also provides that single parents are entitled to 4 months parental leave. It is a noble perspective that parents ought to choose and to share these responsibilities during the very first 4 months of a child's life. But certainly these amendments have caused a lot of uncertainty, a lot of headaches and thought around how to manage all of these new provisions. You will remember that the Constitutional Court provided a reading in of the provisions that will govern the situation until Parliament has the ability to change the legislation. And it seems that Parliament has basically copied and pasted the provisions that the court gave us, with two important exceptions. The first one is in relation to the sharing of leave. And you will recall that it states that where the parties cannot agree, the parties to the parental relationship, where they cannot agree on that apportionment of, how many days or months or weeks the respective parents will take leave, then it will be apportioned as equally as possible. The question is, who does that apportionment? And that is where the employer becomes involved. Not ideal for an employer to be involved in these kinds of intimate domestic issues between parents. And for that reason, it is proposed in the amendments that where there isn't agreement, the birth mother may take the entire period or such time as she may decide. So it's for the mother to decide what the apportionment is, and the employer would then give effect to that choice. Importantly, this only applies where there is a birth mother. So in the case of adoptive parents or parents that became parents through surrogacy, that isn't going to be applicable. And that raises the question, what do you do then when there isn't agreement between those two parents? Arguably, it is then for the employer to become involved. Which employer? Is it in which of the two parents' employer? That is the question. And if there isn't agreement between those two employers, what is the default? So that is something that still needs some funnel beating and further thought. Then another potential unintended consequence was that it's not impossible, but it is unlikely that a birth mother would have a child within 12 months, two children within 12 months. And it is very possible for men to birth children, more children in a 12-month period. So in order to limit the number of parental leave occasions, the legislation now proposes that apart from the birth mother, other parents may only take parental leave once in a 12-month period. So if it happens that a birth mother becomes a mother twice in 12 months, that is an order, and she will be entitled to 4 months parental leave. But for any other parent, if you adopt a child, for example, and within 12 months you adopt another one, on that second occasion, you are not going to get your parental leave. So arguably that introduces a further differentiation, and one would need to think whether that is potentially unfairly discriminatory. If you haven't yet considered amendments to your maternity, commissioning leave, adoption leave policies, it is worth doing so, and there are various options that we would be happy to talk you through on how to deal with the new regime. But it is important that one considers the employer's specific circumstances and all the factors that play a role, especially in relation to payment and the granting of benefits during the parental leave period. It might be easy to just simply give paid leave to all employees, but in male-dominated workforces, this might be quite a challenge. That is parental leave. I'm not going through all the provisions of the reading in. These are the two important changes that's introduced by the draft legislation. Then secondly, severance pay. That is proposed to double. The minimum amount of severance pay now is 1 week for every completed year of service. The proposal is to make it 2 weeks, but the proposal is to only let the 2 weeks kick in once an employee has completed a year of service after the commencement of the legislation. So it's not going to apply retrospectively, it will apply prospectively. That is a considerable amendment, and yeah, in the current financial circumstances, we're not sure that that is a wise amendment. Then the UIF is proposed to be amended so that any parent can claim parental benefits up to 17.32 weeks. In the case of stillbirth or miscarriage in the third trimester, the employee is still entitled to claim for 17.32 weeks. And there is a misalignment there with the BCA, which only provides for leave in those circumstances of 6 weeks. So that is something that we are flagging. But yeah, just to be aware of these amendments. Of course, the amount that we pay in UIF contributions are determined from time to time by way of a notice in the Government Gazette. We do not know what the proposal is in relation to contributions, whether they are proposed to double or be amended at all. So that remains to be seen. Then on the LRA, you will remember that a new code of good practice was introduced last year, in terms of which it is now made very clear that the procedural fairness requirements do not need to comply with a criminal law standard. What you are required to do is reflect, think, listen to the employee's version, give the employee a proper opportunity to respond to the complaints regarding poor performance, misconduct, all of those. But it isn't supposed to be a very acrimonious hearing type process. This principle is now added to, or proposed to be added to Section 188 of the LRA. And in terms of this section, you will recall that it says a dismissal that is not automatically unfair, so under Section 187, is unfair unless the reason is a fair reason related to the employee's conduct, performance, or incapacity, or the employer's operational requirements. And then it says the dismissal must be effected in accordance with a fair procedure. So what is now inserted or proposed to be inserted in 188 is that the employee will be given an adequate and reasonable opportunity to respond to the reason for dismissal. Again, the underlying message and principle is that we do not require full-on criminal-style hearings. We need a reasonable and adequate opportunity to respond to the employer's reason for dismissal. Then, a very important proposal. It says Section 188, which deals with substantive fairness, there needing to be a reason, and procedural fairness, this opportunity to be given to state a case in response. This does not apply to new employees during the first 3 months of employment or whatever longer probation period is contained in the employment contract. If you have a longer probation period than 3 months, that must obviously be reasonable and operationally justifiable, which is often the case because it takes time to performance manage, to give guidance, and to give the employer a proper opportunity to perform at the required standards. So if you, for example, have an operationally justifiable probation period of 6 months, that employee is not entitled to a fair process or a fair reason for termination. It effectively renders employment at will, and you would simply give notice of termination under the contract if you want to terminate that employee's employment. That's new for South Africa. I would be interested to hear how you feel about that. Then Section 189A, where a facilitator is appointed to assist with the consultation process, the employees can go directly to court after the 60-day period after they've been retrenched. It is now made clear that they do not need to first refer the dispute to conciliation. I think the thinking there is that the CCMA is already involved through the facilitation, and therefore the matter can now simply proceed to the Labour Court. The subsections 13 to 18 are proposed to be deleted. These are the provisions that deal with the requirement to bring your procedural fairness claims immediately or very soon, but within 30 days of the date of the dismissal. Those applications are brought by application. So what happened is a proliferation of disputes. Employees would institute a claim for procedural unfairness, and they would then subsequently also bring an action based on the substantive unfairness of the retrenchment. And often these cases would be consolidated into one. The complaint might be, we were not consulted on selection criteria. That's a procedural complaint. The result of the consultation on selection criteria might be that the selection criteria that were used were not fair and objective. That is a substantive fairness complaint. So it makes sense for all claims related to a retrenchment to be brought in one forum by way of one process, which would be the action procedure after termination. So we think that streamlines these retrenchment disputes. Then the last thing that I will focus on in relation to amendments to the LRA is that for employees earning above a threshold amount to be determined by the minister, but that is proposed to be 1.8 million a year, those employees will not be entitled to the remedy of reinstatement or reemployment. They will only be entitled to claim compensation. And their compensation that they can claim will be limited to 12 months, or if it is less, this cap of 1.8. So if an employee earns 3 million a year and is contesting the fairness of a dismissal, that is perhaps for poor performance, and it is found that that employee was unfairly dismissed, that employee cannot be reinstated, and any compensation that's ordered cannot exceed the cap of 1.8. So that employee is not going to get the full 12 months remuneration. Of course, in the case of automatically unfair dismissals, reinstatement is still available. But yeah, that is a very interesting development. So those are the most important amendments that we wanted to bring to your attention. Please have a look in the chat. There is a message from Chloe We have published news flashes on these proposed amendments and have a look at those. And if you want to make comments, please do so by next Friday. Then I'm just going to move on sommer to the next case, and that is Eskom versus Erasmus. That is an affirmative action case that made its way to the Labour Appeal Court. Now, Mr. Erasmus was employed by Eskom since 1988. He's a lifer, that we would say. He was employed as a senior advisor outage coordinator, and he applied for the role of senior manager outage execution. They have various processes in relation to promotions and appointments, and one of these is that a GA13 form staff requisition must be completed, and that was done by the manager, Mr. van Staden, that had the authority to sign that document. This document stated that Mr. Erasmus, who is applying for the role, is a white male. The pipeline was considered, pipeline in respect of progress towards affirmative action, and there's budget for this role. Those are things that are required internally in Eskom to be confirmed. The employment equity manager then said, no, it's actually necessary that we must have an African male appointed to this role or females of any race. But Mr. van Staden really wanted Mr. Erasmus to be appointed. There were many applicants. Many of them went through the interview process, and eventually Mr. Erasmus was the successful candidate, but he wasn't appointed. So he lodged a grievance, and in that grievance he said this was unfair that he wasn't appointed. There's no adverse effect on the employment equity targets at that level. So it doesn't make sense to take race into consideration in these circumstances. Yes, in the department as a whole, white males are overrepresented by 16%, but in respect of his particular appointment, it is not going to make a difference to the reaching of targets at that level. So the presiding officer of that grievance said, there can be a second round, and if no suitably qualified individuals from the other race groups are identified, in those circumstances, he can be appointed. So Mr. Erasmus took the matter to the Labour Court, and something that was interesting is that he indicated on his application form that he is African, not a white male. And he said he did that because if he didn't, he would not be shortlisted, and that was common cause. They wouldn't even look at a white male, even though there might not be any impact on the reaching of the employment equity targets at that level. And the court said this is not okay. It is not fair to completely exclude people from overrepresented groups. This is an absolute barrier. So that, taken with the fact that there wouldn't have been a negative impact on the reaching of the employment equity targets, caused the court to say this constituted unfair discrimination, and Mr. Erasmus actually won the case. So Eskom went off to the LAC. Now, the pipeline argument is what won this case for Eskom. They said, no, we need to make sure that we have a pipeline of suitably qualified people that can be ready to take up higher roles in the organization. And the court said, yes, this is a fair argument. This pipeline argument is not contained anywhere in the employment equity plan. Secondly, you set your targets per occupational level. So if you have the need to make sure that you have sufficient candidates from the lower levels to be considered for higher levels, you have more aggressive targets at your lower levels. If the facts are that you are actually meeting your targets at the lower levels, then by using this pipeline argument, you are applying higher occupational level targets to the appointment of lower level employees. So that is something that I think needs further deliberation in our courts. I am also very disappointed that the Labour Appeal Court didn't take the opportunity to give us a proper explanation of what lawful affirmative action looks like. We have two paragraphs dealing, well, three paragraphs dealing with this issue. And it really relates around the pipeline, and that wasn't even in the plan. No interrogation of the actual targets at the actual levels that were involved in this case. So potentially something that might reach the Constitutional Court, but yeah, we will see. Definitely, if you are excluding overrepresented groups from being shortlisted, that could be an absolute barrier. That finding wasn't set aside on appeal, so that still is good law. And then lastly, very interesting case on constructive dismissal. So this relates to ADT, and it was in the time period that Fidelity was acquiring ADT way back in 2016. And within all this, the transaction discussions and so on, there was an ExCo meeting. And at the time, Mr. Maleka, who was the applicant in this case, was reporting to Mr. Clarkson, the MD. And in that meeting, he announced that henceforth, Mr. Maleka would now report to Mr. Quinn, and Mr. Quinn will report to him, Mr. Maleka. So essentially, they included another layer between Mr. Maleka and Mr. Clarkson. This change would take effect when the transaction took place, the Fidelity ADT transaction. Mr. Maleka was quite upset about that. He raised it with Mr. Clarkson afterwards, and he said, this is a demotion. You're putting another layer in between me and you. And he wasn't consulted about the situation. Mr. Clarkson said, yeah, it is just a structural change. We don't know the actual reason for this. It's not apparent from the case. But your pay isn't changing. Your duties and responsibility are not changing. It's really just a structural issue. Next thing, Mr. Maleka resigned. He didn't refer a dispute to the CCMA for an alleged unfair demotion. He said, no, this is making my employment intolerable and I am resigning. Okay, so in the CCMA, on the constructive dismissal case, Mr. Maleka said his status was diminished and that is why he resigned. The commissioner asked him, so how did this make your employment intolerable? And he said to deal with Mr. Quinn made life intolerable. Now, it would be interesting to know how he would deal with Mr. Quinn, just in principle. That was That was his reason. The commissioner said, no, this is not a constructive dismissal. This was not intolerable. This was more about ego. So off they go and they said, case dismissed. So Mr. Maleka took the case to the Labour Court. The Labour Court said, no, there was no reason why you didn't follow a grievance process or anything like that. You just simply resigned in the face of this change. This is not what a constructive dismissal is about. So the review was set aside. Mr. Maleka, he is a fighter. He went to the LAC. The LAC says, no, your remedy was to refer a dispute to the CCMA on the basis of an alleged unfair labor practice, unfair conduct by the employer related to demotion. This was not a constructive dismissal. Again, case dismissed. Still, Mr. Maleka took this to the Constitutional Court. And there, the majority said the threshold for intolerability is high. It is not just difficult or unpleasant circumstances or conditions that will give you the right to say the employer is making my life intolerable. The court said even a breach of contract or deduction from salary or disciplinary processes might not be sufficient to meet this threshold. It must objectively be unendurable and agonizing. That is a high threshold. And the employer must be the cause of this unendurable and agonizing situation. And these conditions must bring tolerance to breaking point. So you can see this is a high hurdle to get over. The court said in this case, the resignation was based on the anticipated difficulty to deal with Mr. Quinn, not with the actual existing intolerable conditions. And these anticipated difficulties couldn't support a claim that my employment has become intolerable. So the court confirmed that he didn't meet the requirements for a constructive dismissal and that he had failed to prove that the conditions had become intolerable. So what must we know? You must exhaust your internal processes first, and you can only avoid doing so if that is in fact justifiable in the circumstances. So the case was dismissed. And then the minority thought it is wise to give their own judgment. And they said, why was Mr. Maleka now required to report to Mr. Quinn? Clearly, this was just because of race. And that is an appalling insult. And that met the test for constructive dismissal, and that was unfair. Now, not in the CCMA, not in the Labour Court, not in the Labour Appeal Court, not in the Constitutional Court was there any evidence that this was done because of Mr. Maleka's race. This was an assumption that the minority made. So it was completely unsupported by evidence. It goes against all the basic principles in litigation that the court must determine the matter on the pleaded and argued case. It is for the parties to make out their case. It is not for the court to do it on behalf of a party. There was no opportunity given to the employer to even say anything about this assumption that this was race-based. So it is concerning that judges of the Constitutional Court think it's okay to assume things without a factual basis. In this case, this is not binding. The majority judgment is binding with very clear indications of the test for constructive dismissal, which we are grateful for. But it is important that judges make decisions based on evidence. That is a basic principle. And that brings to an end my two cases. Thanks, Liz.
Thanks, T. Before we move on, though, there's a question for you going back to the amendments. It's how does the amendment to section 188 with respect to the dismissal of new employees of less than 3 months relate to the constitutional right of everyone to fair labor practices?
Yeah, it is a balancing that needs to be applied. I think there is recognition that employers, find it difficult to employ employees because of the strict procedural and substantive fairness requirements, and this might come from, a place where it needs to be made a little bit easier for employers to hire and fire in that time period. It is a limitation of the right to fair labor practices, and it will have to pass muster under the Constitution and the limitations clause ultimately under the Constitution. I would not suggest that you just leave an employee that has just joined and just make them swim. And if they can't reach the standards, that you then just dismiss them. No, I think a fair employer would still be very alert to performance concerns, give guidance, have discussions. But what it does mean is that in those circumstances, in this very limited time period, the employer is relieved of going through a hearing process, whether that is in writing or a PIP process, a very, very formal type process. And that might be something that employers might breathe a sigh of relief about. But ultimately, yes, it will have to be that balancing act will have to pass the Constitutional Court's scrutiny.
Thanks, Talita. So there's some very interesting amendments, I think, being proposed. So I, for one, am very interested to see, what the amendments will actually look like in the final form. But there do seem to be some positives there. Our next speaker is Nadine Mather. Nadine will be speaking also on a constructive dismissal case, and I'm quite interested to see what that case found in light of the ConCourt judgment, because if I'm not mistaken, that judgment was a couple of months before this Constitutional Court judgment. And then after that, Nadine will deal with a case on unlawful competition and the use of confidential information. So over to you, Nadine.
Thanks very much, Roz, and good morning, everyone. It's great to have you joining our first employment law update for the year. As mentioned by Roz, I will be building on the topic of a constructive dismissal as discussed by Talita, which is a topic that often arises in practice, but as we all know, is notoriously difficult to prove. In this regard, I will be exploring the Labour Court judgment of Lewis versus CCMA and others, which, as Roz pointed out, was handed down in November last year. Now, in this matter, the employee, Adele Lewis, was a senior employee employed by the company in a debt collection business. She started in 2019 as a revenue manager and later rose to the position of Chief Performance Officer, forming part of the company's executive committee. Now, during the COVID-19 lockdown in 2020, she requested to relocate from Johannesburg to Cape Town for personal reasons relating to her children's schooling. The company agreed to the relocation, and she relocated, purchased a home, and established a lovely family life in Cape Town. Now, one of the key disputes in this matter was whether the employee's relocation was permanent, as the employee contended, or whether it was merely a temporary remote working arrangement, as argued by the company. Now, in 2023, the company experienced significant financial strain. It lost a number of major clients and a substantial portion of its revenue. And this triggered internal restructuring, including the dissolution of the Executive Management Committee and the establishment of a new revenue committee from which the employee was excluded. And shortly thereafter, given the business crisis that the company was in, the company made a decision to terminate all remote working arrangements and required employees to all return back to the office with effect from 1st of January 2024. Now, this decision, of course, had a profound impact on the employee. She had uplifted her whole life, her children found great schools in Cape Town, and in the circumstances, she actually requested the company if she could have an extension and rather relocate by March 2024. This request was refused. And around the same time, the relationship between the employee and the CEO began to deteriorate. Communications became strained, more formal, and according to the employee, they became increasingly critical and sort of exclusionary towards her. Now, in November 2023, the employee submitted a medical certificate to the company, booking her off work until December 2023. And the certificate recorded that she was suffering from anxiety and depression, which was due to work-related stress. Now, in response, the company immediately accused the employee of abusing sick leave. They questioned the legitimacy of her medical condition. They informed her that her absence would be unpaid, and they actually threatened to institute disciplinary action against her relating to an abuse of sick leave. Now, in response, the employee decided to provide the company with further details relating to her medical condition. She explained what her medical condition was and obtained a full medical report from her doctor that she furnished to the company that demonstrated that the employee had a history of depression, and this had simply been exacerbated in the circumstances relating to work-related stress. Now, interestingly, in response to that, the company responded and said, "That's fine. We acknowledge your sick leave and it will be paid." A few days later, the company sent the employee communication saying, "Sorry, the communication we sent was actually premature. We weren't supposed to send it, and we're reverting back to our original position, which is you're abusing sick leave, you're completely malingering, this is related to the relocation request, and your sick leave will be unpaid." And on that basis, the employer actually only received payment for 8 days in November 2023. A few days later, the employee resigned with immediate effect, and she stated that her working conditions had become intolerable. And on the same day, she referred a constructive dismissal dispute to the CCMA. Now, having considered the evidence, the CCMA found that the employer had failed to prove on a balance of probabilities that such an intolerable situation had been caused by the company, and she was left with no alternative but to resign. Now, disgruntled by the position, this outcome, the employer referred the matter on review to the Labour Court. Now, before the Labour Court, the employer argued that the company had rendered her continued employment intolerable, and this was through a pattern of conduct, right? This included the breakdown of the communications, the exclusion of her from your management structures, their unreasonable refusal to grant her an extension in respect of the relocation, and most importantly, the company's conduct in respect of her sick leave. She contended that the company unjustifiably accused her of being dishonest, it disregarded medical evidence, and of course unlawfully withheld her salary. And in these circumstances, she was left with no alternative but to resign. The company, of course, on the other hand, argued there was no constructive dismissal. It maintained that remote work had always been temporary. that the decision to require employees to return to the office was driven by legitimate business reasons. The company was in a business crisis and required all hands on deck, and that the employee had agreed to return to the office, had failed to utilize any grievance procedures, and her sick leave and the timing thereof was just too suspicious with reference to the relocation. Now, the court turned to the legal test for constructive dismissal, and as we all know, that is a situation where the employee resigns because the employer's conduct made their employment intolerable. This is an objective test. The court reiterated that the question is whether the company's conduct was such that a reasonable person in the same position would have found the working conditions intolerable. So 3 elements must be established. The employee must have resigned, the resignation must not be voluntary, and the employer must have rendered continued employment intolerable. As Talita mentioned, and similar to the Constitutional Court, the court did emphasize here that mere unhappiness, frustration, or even workplace tension is not sufficient. In the Labour Court's view, they said it must be conduct that destroys or seriously damages the relationship of trust and confidence. So, applying these principles to the facts, the court analyzed the matter in stages. First, regarding the breakdown in the communication, the court accepted that there had been a deterioration in the relationship between the employee and the CEO. However, it found that this was largely due to the operational pressures that was being faced by the company. And as such, this amounted to mere unhappiness at work and on its own didn't establish intolerability. Second, the court considered the decision to terminate the remote working arrangement. And it found that the company's decision in this regard was rational, it was reasonable, and it was driven by legitimate business needs, right? They needed all hands on deck. So whilst it had a significant impact on the employee personally, the company's conduct in this regard was not unlawful and it was not calculated to destroy the employment relationship. So therefore, it wasn't intolerable. The decisive issue and what the court described as the tipping point was the company's handling of the employee's sick leave. The court found that the employee had complied with internal procedures. She'd notified the company of her illness and provided a medical certificate, further supported by a letter from her doctor. And the company's approach, however, was not a sympathetic one. The company accused her of malingering, questioned her integrity, and failed to verify her medical condition. And it, of course, reversed its earlier approval in respect of her sick leave and withheld a substantial portion of her salary. So the court was very critical of this conduct. It held that the employer had other options available. It could have sought clarification relating to the medical condition or placed her on unpaid leave if she didn't have a sick leave entitlement. But instead, it opted to adopt a very accusatory and punitive approach, which actually breached the company's implied duty of trust and confidence. So this was a situation where compassion was replaced with confrontation and where a medical issue was actually weaponized by the company into a disciplinary matter. And the court found this destroyed the trust relationship, and it was this that rendered continued employment intolerable. Now, turning to the question of alternatives, and as Talita mentioned in the Constitutional Court, there's always been this big emphasis on, did the employee pursue internal grievance procedures or steps internally to try and resolve the issue? Now, in this specific case, the company, of course, argued that the employee had other options. She didn't have to resign. There were grievance procedures to be followed. However, the court actually rejected this argument, and it held that given the company's conduct and their fixed stance relating to the employee's sick leave, they found that any internal process followed in terms of a grievance would have actually been futile. The company had already showed its stance. It was not interested in listening to the employee. So any process the employee would have invoked in this regard wouldn't have taken the matter further. And on this basis, she had no alternative but to resign. So just in summary, the court found that considering all the events, and whilst the earlier events of the communication, the termination of the remote working arrangements did not themselves constitute intolerable conduct, the company's handling of the sick leave issue was really the straw that broke the camel's back. And the employee was considered to be constructively dismissed in these circumstances. Now, in terms of the remedy, the court awarded compensation but did not award the employee the maximum of 12 months compensation as she had requested. Instead, it limited that compensation to the actual period of loss from the employee. They had regard to the fact that the employee was a senior executive and that she secured alternative employment shortly thereafter her resignation. So the total compensation the court awarded was around 310,000 Rand, which represented the balance of her unpaid days in November 2023 in respect of the sick leave and an additional 3 months remuneration thereafter. Interestingly, there was no award as to costs, and the court said in this regard that both parties had some sort of responsibility when it came down to the breakdown of the relationship. So there was no award as to costs. So just in conclusion, and in terms of some key takeaways, as mentioned by Roz and Talita, constructive dismissal remains a very high threshold. It is not easily established. Mere unhappiness is not enough, and something more is required. And in this case, the something more that was required, as the court stated, was conduct that destroys the relationship of trust and confidence. Secondly, employers are entitled to make difficult operational decisions, even where these adversely impact or affect employees. So it's not the issue you cannot make decisions like, terminating remote working arrangements. The issue here and of central importance was the trust in the employment relationship. And it was the issue of an employer's conduct in treating a situation, here being the medical condition, in a manner that was suspicious, was condescending, accusatory, and inconsistent. And it was this risk that really fundamentally breached the trust relationship, rendering the resignation a constructive dismissal. So I will now turn to my second judgment, which deals with the important and increasingly relevant area of law, namely the protection of confidential information and personal information in your employment context, particularly after the termination of employment. I will be discussing a High Court judgment of Zulu Inyala Game Ranch versus Bukes and another. In this matter, the company offered bespoke wildlife and cultural vacation experiences, primarily to international clients. So its business model relied heavily on repeat customers and personalized services. The first respondent, Christian, was employed by the company for approximately 11 years as a game ranger. Now, he was not only responsible for guiding guests, but also for the marketing of the company's services and facilitating the excursions. So through his role, he developed direct relationships with customers and had access to the company's confidential information when it came to your customer contact details, their personal preferences when it came to their wildlife vacations, and the company's pricing structures. Now, in 2019, a competing business called Custom Trails was registered in the name of Christian's wife. And 6 years later, in 2025, the company discovered that whilst employed, Christian had been marketing and selling Custom Trails services to the company's own customers. He was effectively competing with his employer, and of course using his employer's customer base to do so. Now, following this discovery, Christian was dismissed by the company in August 2025. Shortly thereafter, Custom Trails obtained a license and began to operate in the same exact game reserve as the company and began offering services directly competing with the company's customers. Now, the company's case was not that Christian could not compete. There was no restraint clause in this matter. The company's case was instead the issue that Christian had used confidential and personal information obtained during his employment with the company to springboard this competing business. So the company decided to urgently approach the High Court, seeking an interdict to prevent Christian and Custom Trails from from using and exploiting their confidential information. Now, before dealing with the merits, Christian and Custom Trails raised two preliminary points, which I'll address just briefly. The first was that they argued the matter was not urgent. The court rejected this argument, finding that potential misuse of confidential information justified urgent intervention. Now, the second argument they raised was there had been a non-joinder, specifically that the customers themselves should have been joined to the application. The court also dismissed this point, holding that the joinder is only required where a party has a direct and substantial interest in the outcome of the matter. Now, in this case, the customers would not be prejudiced by the order. They remained free to engage with the company, with Custom Trails, with whomever they wished. So they had no direct and substantial interest in this matter. The court then turned to the merits of the case. And the central issue before the court was whether the information in question constituted confidential information and whether its use by Christian and Custom Trails amounted to unlawful competition. Now, the court applied the well-established test for confidential information, and in this regard, three requirements need to be met. The first requirement is that information must be capable of application in a particular trade or industry. The second is the information must be secret and confidential. So in other words, it's not public knowledge and it is known only to a limited group. And third, the information must have economic or business value. Now, in applying this test, the court had little difficulty in finding that these three requirements were all met, right? The customer database was central to the company's business model. It enabled the company to provide a personalized service and to maintain relationships with high-value international clients. This made it, of course, commercially valuable, but also directly applicable in the industry. The information was clearly confidential. It was not publicly available and was only known to the company and its employees. And finally, the information had clear economic value. It was the company's ability to attract repeat business depended on this client data. This made it a key asset of their business. In addition to the common law principles that were applied, the court also placed reliance on the Protection of Personal Information Act. The court found that your customer information constituted personal information as defined under the Act. And in terms of Section 20 of POPIA, it found that Section 20 imposed a duty on any person processing personal information to treat it as confidential and to not disclose it without the necessary authorization. So whilst Christian attempted to distinguish between personal information and confidential information, which the court, of course, rejected as irrelevant, the court did find that Christian had not only breached his common law obligations and his duties of confidentiality, but also statutory duties under POPIA. The next issue in the matter was whether this conduct amounted to unlawful competition. And in this regard, the High Court held that where a competitor uses confidential information that had been obtained improperly to gain an advantage and therefore causing harm to another business, this constitutes a wrongful and unlawful act. The court, of course, also referred to your springboard doctrine, which recognizes that a party who uses confidential information gains an unfair head start, right, in the market. This doctrine was directly applicable to this case. Custom Trails was able to launch a competing business almost immediately after Christian's dismissal, using the company's own customer base to generate business. So in summary, the court found that this gave Christian and Custom Trails an unfair competitive advantage and constituted unlawful competition. So having found that the information was confidential, it had been misused, and that this constituted unlawful competition, the court concluded that the company was entitled to an interdict. And an interdict was granted in which both Christian and Custom Trails were restrained from using, copying, publishing, or disclosing the company's confidential information, and of course from approaching, contacting, or soliciting the company's customers. In addition to this, there was an order that directed Christian and Custom Trails to delete all such information they had on any electronic devices and on any cloud server, and also to hand over all hot copies of the confidential information. Now, lastly, and just to reiterate, the court did clarify the scope of the relief granted. The relief was not aimed at preventing Christian from working for Custom Trails or from competing in the industry. Instead, it was tailored to prevent the use of the company's confidential information. So the court emphasized that the respondents could still conduct business. That's not the problem. But they could not use the company's confidential information to do so. So in conclusion, and just a few takeaways on this matter. First, even in the absence of a restraint of trade, employees remain bound by their confidentiality obligations, and these apply after termination of employment. Where an employer seeks to enforce confidentiality obligations in an employment contract by way of an interdict as opposed to a damages claim, it's not necessary to prove damage or fault on part of the employee. So one needs to just prove that there was unlawfulness in the conduct. And your unlawfulness is determined, as the court mentioned, with reference to your public policy yardstick. Is it an unlawful act or wrongful act? So ultimately, the court has said it's clear that while competition is lawful, competition built on the misuse of another's confidential information is not. And thirdly, just to note, in terms of this remedy, you need to act swiftly if you're going to approach a court for an interdict, right? This was found to be urgent, and urgency will depend on the factual circumstances. And in addition to simply an interdict saying you can't use the confidential information or non-solicitation obligations, the remedy that they are actually ordered to delete the information and to hand over the information is quite prevalent in this matter. This allows you to effectively police and enforce the interdict. So employers should consider seeking this ancillary relief if it is going to approach the court for an interdict. And lastly, I suppose, be remiss to overlook the court's application of the provisions of POPIA. Whilst, yes, customer information constitutes personal information under POPIA, and such information is required to be processed with reference to your conditions of processing of personal information, the court's reliance on Section 20 of POPIA, I suppose, was interesting in the circumstances. Section 20 of POPIA actually regulates information processed by an operator, which is a body or person that processes information on behalf of a responsible party without coming under the control of the responsible party, or from a person acting on behalf of the responsible party. So in these circumstances, that third party is required and has a legal obligation to keep the information confidential. The court's approach here was that employees fall under the concept of that third party under Section 20. It is a novel interpretation. I suppose it's a very generous interpretation in the circumstances, in that it should arguably be limited to operators or third parties and not employees that work for the responsible party. But having said that, whether this position will go untested does remain to be seen. But that is the current stance adopted by the High Court on that issue. Thanks very much, Roz.
Thanks, Nadine. Very interesting case, I think, on the use of confidential information. The next case is also going to be one dealing with unlawful competition, and Melissa Kocher is going to be taking us through that. And then Melissa will also take us through a case where the court emphasizes the importance of properly identifying or pursuing your actual claim. So if I'm not mistaken, in that case, the court's attitude was you really can't forum shop. You need to see what your actual claim is and then use the appropriate remedies. Don't try and dress it up as something else. But over to you, Melissa.
Thanks, Roz, and good morning to everyone. So the first case I'm going to be discussing, which is related to breach of confidential duties that employees owe to their employers, is G4S Depositor versus Harmsa. It's a Labour Court judgment from November of last year. And it's similar to the case that Nadine just discussed. There wasn't a restraint of trade in this particular case. The issue wasn't about joining a competitor, but it was rather about a breach of the duty of confidentiality that an employee owes to their employer. So in this case, G4S Depositor is a cash and payment solution enterprise, and it specializes in advanced automated cash management solutions for businesses of all sizes. The employee in question here was a senior employee. She was the head of the retail for cash solutions, and she had unfettered access to all of the company's confidential information that was contained on its systems. Her contract of employment did have a confidentiality clause, and the CCTV footage showed that on a weekend, on a Saturday, she entered her employer's offices together with an unidentified man and another woman, and she was seen to be removing various items from her office, including a box of hard copy files and documents. Then on Sunday, the systems showed that she started downloading documents from the employer's Google Drive repository, and her download started at 11 in the morning, and they continued until 7 p.m. that night, and then carried on again the next morning on Monday at 6 a.m. So all in total, she had downloaded 1,083 documents over those 2 days. And this was compared against her normal rate of downloading documents, which was just about 150 downloads per month. She took most of that information and she saved it onto her external USB device that was connected to her laptop. And she also used surreptitious means to download the data. She used a Microsoft browser rather than Google Chrome, apparently to avoid her online activity being tracked. So after she'd gotten all of this information and she downloaded it, she then went to the office on the Monday and tendered her resignation. It came to light that she was joining a competitor of the business. She was going to join Fidelity, who's also in the business of cash and payment solutions. And after 2 weeks, the company decided to put her on garden leave because they noticed the suspicious activity and they wanted to investigate further. In that 2-week period, importantly, she didn't do any sort of handover. She didn't say that she had downloaded information or that she had deleted information. And then when she returned her cell phone, all of the factory settings had been wiped off and the data was no longer on the cell phone when she returned it. Also, all of her download logs and her browser history on Google Chrome had been deleted for those relevant periods in question. So the company acted very swiftly. They approached the court on an urgent basis, on an ex parte basis to get an Anton Pillar order and to get interim interdict relief, pending final relief. And for those of you that are not aware of what an Anton Pillar order is, it's an application that's made without notice to that individual. It's heard in camera, so it ensures that there's confidentiality around the case. And essentially the applicant seeks permission from the court to search a premises and to seize relevant evidence which otherwise might be destroyed. So it's quite a useful litigation strategy when you are dealing with the misappropriation of confidential information. So the company successfully obtained the Anton Pillar order on an urgent basis. They instructed the sheriff to attend at her premises, and when the sheriff got there, he located and seized 17 workbooks, including contracts, commission policies, national sales meeting notes, customer member list files, several flash drives and CDs containing digital information. And at first, she was a little bit less than forthcoming, and only towards the end of the search did she produce that external hard drive, which had the bulk of the downloads that she had taken from the company's system. So when she was questioned about this and in her papers, she said that she had downloaded that information to do a handover, which we know was untrue because she didn't do any handover during that time. And she said that she needed access to those documents because it was consistent with her duties and she was working from home, which was also untrue because she was placed on garden leave, so she wasn't required to do any of her duties. She said that there was no wrongdoing in her conduct, and that the true motive behind this Anton Pillar order and this urgent application that they brought was retaliation against her because she had decided to join a direct competitor. She also tendered a letter of undertaking, which we often get in these types of cases where people promise not to do bad things despite all the damage they've already caused. But the court found that this letter of undertaking was heavily qualified. So it was really not an undertaking at all. It had various caveats to it saying, you know, she'll make sure she only has reasonable use of the confidential information and only insofar as it relates to unlawful competition. And the court didn't accept that, and they accepted that employers do not have to rely on these false promises brought by employees who have already breached trust. In that case, the court said that it's an implied term of every contract of employment that the employee is going to act in good faith towards their employer and serve them honestly and faithfully. And this includes that fiduciary duty not to work against your master's interests and not to place yourself in a position of conflict with the interests of your employer. It reiterated that the relationship between an employer and employee is one of trust and confidence, and that the duty to preserve confidential information doesn't just exist during the employment relationship, but extends after the period of employment has ended. And that applies for as long as the confidential information remains confidential. So Nadine mentioned the test that's used by the courts to determine when information is confidential. Those principles apply in this case as well. So for as long as it's not in the public domain, it has commercial value, you've got that duty of confidentiality not to disclose it. The court restated those principles. It confirmed that customer lists is going to be confidential information about business opportunities, as well as proposals, marketing submissions, pricing information, and the like, all amounts to confidential information, which is covered by this duty of good faith, not to misappropriate that information for your own benefit or for the benefit of a third party. In relation to the undertaking that she tendered, the court said that an employer can't be expected to just sit by and cross its fingers and hope that the employee is going to be honorable with the undertakings, because that's the argument they raise when you rush off to court, that, oh, well, you shouldn't go on an urgent basis and go seek this relief because I've already given you all the undertakings in this document. The court essentially said that document's not worth the salt that it says, and it's effectively no undertaking at all, because it's entirely dependent on an employee's good faith and her personal views as to what is reasonable and what is unlawful competition. So in that case, the court granted the final interdict, which restrained her from using, distributing, copying, publishing, or using any of that data or intellectual property in any formal manner whatsoever, and awarded costs against her as well. So for this case, a key takeaway is that even if you don't have a restraint of trade clause and an employee is going to join a competitor, you can still rely on the employee's duty of good faith to employers, which includes an obligation not to work against the employer's interest and place themselves in a position of conflict. And this includes even if you don't have an express confidentiality clause in the employment contract, because these are common law duties of good faith. And when you've got a reasonable belief that a departing employee is going to be misappropriating confidential information that's going to be used by themselves or third parties, especially competitors, you should consider whether this is a case to approach the court on an ex parte basis without notice to that person to get an Anton Pillar order in order to get control back of your confidential information and documents. So it's quite a nice case. It restates the principles on confidentiality and duty of good faith, and also gives employers some more options in terms of how to get control of the data that can be used together with the relief sought in Nadine's case, which was deleting all confidential information, retrieving it, etc. Then the second case that I'm discussing is called Kula and others versus Busamed. It is a High Court decision that was handed down last month. And as Roz mentioned at the start, this was a case which was disguised as a contractual claim when in fact it was really an unfair dismissal claim. Interestingly, the applicant in this case was also trying to rely on relief in terms of Section 163 of the Companies Act, and that safeguards minority shareholders and directors' rights from oppressive or unfair prejudicial conduct from the company or a related entity that disregards their own interests. And it's a particularly interesting case because of the dual role that many senior executives play at companies. They're often shareholders, they're often executive directors, and this particular case looks at the nuances in the interplay with the LRA and the dispute resolution framework that we have in place for unfair dismissal disputes, and how these can get muddied with contractual claims and oppressive remedies in terms of the Companies Act. So in this case, Dr. Kula was the CEO of Busamed, and he was also an executive director of that company, as well as an executive director of a related entity, BMC. So he essentially wore three hats. He was the everyday CEO and then an executive director of two companies within the group. Following concerns as to misconduct, his employer sought to suspend him from his position as CEO. There was some disputes as to who his actual employer was, but it's probably in this case there was likelihood to be co-employment of the two entities within the group. And the employer commenced formal disciplinary proceedings against him whilst he was placed on precautionary suspension. He decided not to attend those disciplinary proceedings, and a recommendation was received from the chairperson in his absence. The board of the employer essentially decided to give him an option of mutual separation and said, you can take an option of mutual separation, or we're going to follow the legal route, which is ultimately that they were going to dismiss him. They eventually gave him an ultimatum of 7 days to agree to mutual separation, which he didn't agree to. And before he responded on whether he was going the legal route or accepting mutual separation, he had launched an application in the High Court. He was then dismissed, and so he amended his relief in the High Court, and he basically said that he was seeking relief for the termination to be set aside and declared invalid, and he wanted an interdict preventing the companies from giving effect to his dismissal. And he said, amongst various other things, that the termination process was beset with fraudulent actions, including the employment contract itself. It was apparently fraudulently obtained by the employer. And so he framed it as an illegal termination of contractual rights rather than an unfair dismissal, hence why he went to the High Court and not the Labour Court or the CCMA. And then he evoked that oppressive remedy in terms of 163 of the Companies Act. In this case, the company said that this matter wasn't urgent. His appropriate forum should have been the CCMA or the Labour Court. This was a normal dismissal dispute. And the fact that he's now raised allegations of fraud against his past employer is incompatible with the relief that he was seeking, which was specific performance, essentially being placed back into his position, which in essence is an order of reinstatement. And the company argued that this is indicative of the fact that there's a breakdown of the trust relationship between the CEO and the board, and reinstatement in those circumstances is not appropriate. So in this case, the court restated the primacy of the Labour Relations Act and the framework for labour disputes and the preference for using labour forums, and warned against formulating claims to sidestep the LRA and its processes. So it's referred to the various constitutional court jurisprudence we have on these cases in administrative law, and it endorsed the primacy of the LRA's carefully crafted dispute resolution structure and denounced forum shopping. So, senior executives shouldn't go and see where could they get the quickest relief. Should it be the High Court, the Labour Court? Essentially, if you're looking for reinstatement, then it's going to be via the CCMA and the LRA. And this is a nice preliminary point to raise if you are the employer on the receiving end of this type of claim. So The court acknowledged that whilst the pleadings themselves will determine jurisdiction, and he pleaded it as a contractual dispute and an oppressive remedy dispute in terms of the Companies Act, the court said that one has to have regard to the pleadings holistically. And when you properly interpreted the relief that he sought, it revealed that this was a dismissal dispute where the LRA is the statutory framework in which it had to be determined. The court did acknowledge that there are contractual rights that senior executives will have in terms of the unlawful termination of contracts, but this is separate to your fairness remedies in relation to dismissal. And in this case, the court said that this was an unfair dismissal claim dressed up as a contractual claim. And in this case, the court said that if there is a contractual claim where the employee is claiming that there's been a premature termination of the contract, they can claim a breach of contract under common law, but the remedy should be a damages claim in the ordinary course and not a claim of specific performance because of that unique relationship of trust between an employer and an employee. And specific performance wouldn't be the appropriate remedy in these types of cases. And the court also accepted the company's argument that his claims as to fraudulent behavior of the board was incompatible with an order that of specific performance, which would reinstate him back into his role as CEO, given that there was a breakdown of the working relationship between the parties. So key takeaways from this case is that specific performance in the form of reinstatement is not appropriate if the working relationship has irretrievably broken down. Reinstatement is a labor law remedy, and it should be sought through the CCMA or the labor courts, not as a contractual remedy through the High Court. An employee's own conduct could undermine the relief that they're seeking. So if they're saying there's fraud, then reinstatement is not actually going to be a competent order. And in this case, damages would adequately compensate him for any contractual claim that he would be able to prove in the ordinary course. He wasn't allowed to jump the queue and come to court on an urgent basis. And on that oppressive remedy in terms of the Companies Act, the court said that you can't use Section 163 of the Companies Act to circumvent all of these principles and obtain reinstatement where the legislature did not intend that the outcome of those types of claims would result in reinstatement that should be pursued through other remedies. Thanks, Roz.
Thanks so much, Melissa. Our next speaker will be Louis Mangi. I think everyone knows Louis. He often speaks at these. Louis is going to be talking about a case on Section 197 that really deals with the tricky question of whether a business remains intact post-transfer for the purposes of Section 197 and what that would look like. And the next case that he will be dealing with is off-duty misconduct and, circumstances in which an employer can get, involved where there is off-duty misconduct. Louis, over to you.
Thank you, Roz. So the first case, as Roz mentioned, is going to be dealing with Section 197, and this went before the Labour Appeals Court. I don't want to go into too much detail regarding the exact dynamics around mines and shafts and grafts and grout plants, but just as an overview, I think it's helpful for purposes of background to know that in South African mine, grout plants are constructed and maintained for the purposes of distributing grout to underground mine shafts. And so in this case, and it's helpful to know that for this case, the appellant and the respondent are both in the business of grout pack pumping and both engage in the construction, operation, and maintenance of these grout plants for a range of mine shafts. Now, in November 2021, the respondent in this matter was appointed by a mine to refurbish, operate, and maintain the grout plant at a certain mine shaft. And it's important for this case to know that the mine provided the utilities, materials, and storage facilities through which the respondent would carry out its services. The respondent employed 63 workers to fulfill these services. But what's critical is that the mine provided the utilities, materials, and storage facilities. Thereafter, in 2023, the construction of a larger grout plant was required, and the matter went out to tender. And in 2024, this was then awarded to the new contractor, who is the appellant in this matter. And this is what gives rise to this matter. In essence, the outgoing contractor, the respondent, argued that Section 197 applied, resulting in the automatic transfer of the 63 employees. The incoming contractor, the appellant, disagreed and said that Section 197 did not apply. And to this extent, they argued the following. They said the appellant would be implementing a new shift system. 2, that the appellant would use its own existing employees to fulfill its obligations under the contract. Thirdly, it said that the old grout plant will be decommissioned and a new plant will be constructed by the appellant. Their next point was that the mine will purchase equipment from the appellant, which would be utilized by the appellant in fulfilling its services. They then said that the transaction amounts to the replacement of one contractor with another pursuant to a tender process. And then their sixth assertion was that it's not a tender requirement that Section 197 applies. And on this basis, it therefore argued that no transfer as a business as a going concern occurred. Also of importance for this case, and worth noting, is that the tender documents contained a specific clause which referenced Section 197, and it said the following. It said, in the event that the incumbent service provider no longer requires the services of its employees in the provision of the services, the successful tenderer shall be obliged to abide by its obligations in terms of Section 197 of the LRA. And the appellant argued that this was a non-binding template provision, while the outgoing contractor, the respondent, contended that it signaled an expectation that Section 197 would apply in the event of a change in service provider. So the matter first went to the Labour Court. The Labour Court considered the matter holistically. It stated that when determining whether Section 197 finds application, it's required to undertake a factual inquiry to assess whether the business that performs an economic entity has retained its identity after the transfer. And after considering all the information before it, it found that it did apply. In essence, it stated that the business would retain its identity as the mine provided utilities, material storage, and communications for the rendering of grout pack pumping services to both contractors. So it was providing that to the respondent, and thereafter it would now be providing that to the appellant. So ultimately, the Labour Court found that even if there were changes in technology and staffing, the core economic activity remained unchanged, as in essence, both the respondent and the appellant operated under the same arrangements and conditions and continued rendering grout pack pumping services, meaning the business was transferred as a going concern, and therefore Section 197 applied. The Labour Court rejected the appellant's approach that the applicability of Section 197 hinged solely on whether the objective facts showed that the operational capacity of the respondent had transferred. Then in relation to that clause 20 of the tender document, where the appellant contended it was merely a standard clause with no bearing on the award of the tender, the Labour Court concluded that given the nature of the grout business, it's improbable that this clause in the tender document is a mere standard template. Accordingly, the Labour Court determined that the undertaking business or economic entity retained its identity after the transfer, in that the same economic activity and objective remained, and for that reason that Section 197 applied. The incoming contractor, so the appellant, then challenged the test that was applied by the Labour Court and set out detailed grounds of appeal. I think it was about 15 grounds of appeal that it placed before the Labour Appeal Court. And initially, leave to appeal was refused, and there was a petition, and the Labour Appeal Court then granted the petition. The Labour Appeal Court dealt with it similarly. It first provided an overview of some principles of the Section 197, and it referred to Constitutional Court case in Road Traffic Management Corporation versus Tassima Limited, and it gives the following as an overview when applying Section 197. It says that a business can consist of a variety of components, including both tangible and intangible assets, goodwill, a management staff, a general workforce, premises, a name, contracts with particular clients, the activities it performs, and its operating methods. And it said this is not a closed list, but these factors must be considered, and it must be sufficiently connected to form an economic entity capable of being transferred. So this is in the determination of whether there is a business. The courts then said that the transfer of a business as a going concern is effected when the economic entity which comprises the business retains its identity after the transfer. This seems to be accepted now throughout. The Labour Court, of course, used the same principles. It says typically the identity of the entity that comprises a business comprises the employees, premises, fixtures and fittings, stock, contracts, books, debts, trademarks, and other tangible and intangible assets. This does not mean that it is never possible to transfer an undertaking or business without a transfer of all or some of the components of the business. Rather, as held by the Concourt in Nahawu versus the University of Cape Town, a number of factors will be relevant to the question of whether a transfer of a business as a going concern has occurred. So it looked again at the matter holistically. And then in arriving at its outcome that Section 197 did apply, it looked at very similar principles to what the Labour Court looked at, and essentially applied the following useful key takeaways in the matter. It says that in the context of outsourcing arrangements, whereby one service provider replaces another in providing certain services to a client, operational distinctions in the running of the business, such as more advanced technology, different staffing models or shift systems, and enhanced efficiency, will not assist an incoming contractor in avoiding the application of Section 197, where in substance, the core function of the business remains materially the same. In this case, the court held that these changes didn't alter the business's essential nature, and the court found that when viewed holistically, the core economic activity, which was the provision of grout pumping services, used the same inputs provided by the client to the same client, and this remained essentially constant. The fact that the service was to be delivered more efficiently and at a larger scale across two plants rather than one didn't alter the essential nature of the service being performed. To this extent, the court said, in substance, the appellant continues to perform the same core function as that performed by the respondent, the provision of grout pumping services using the same inputs supplied. The second key takeaway from this matter is that Section 197 doesn't require the transfer of every single asset to give rise to a transfer. Only those assets without which the business cannot be carried on. So in this case, the fact that computers, accounting, software, furniture, and similar office equipment didn't transfer were not determinative of whether a business transferred as a going concern, as these were not the core assets needed to run the business. The essential operational capacity being the ability to provide grout pumping services using the infrastructure, utilities, raw materials, and other assets supplied by the client remained intact. And accordingly, the incoming contractor was able to continue the same economic activity. And then finally, just in relation to that clause, the court provided that provisions in tender documents that reference Section 197 may indicate that the parties contemplated the application of Section 197. However, this application is still determined by whether the underlying transaction gives rise to a transfer of a business as a going concern as a matter of fact and law, not merely the labels that parties give to it. So, in essence, this case just confirmed again the principles, and very importantly, whether it's the core business that the identity is retained both before and after the transfer. And if that's the case, then Section 197 will find application. Then I want to move to my second case. I think that this case is quite interesting in that it deals with two aspects. I think that there's been a bit of focus on the off-duty misconduct aspect of it. But what's quite interesting also was the usage in the investigation process of certain cell phones and providing the PINs to those cell phones to the employer while they were conducting the investigation. So this was a case that came on review to the Labour Court. In the CCMA, there were 8 employees involved. The 8 employees were dismissed by the company. And in essence, the case revolved around an event that took place outside of the workplace. There were 8 employees that were disciplined thereafter in relation to that matter. And what had happened was that there was an employee who was assaulted at the social function. So they left the workplace and the matter actually extends back to 2018. And after that, after the workplace, they went to a social gathering. And later that night, there was an assault carried out on one of the employees of the company. And 2 of the employees were involved in this assault, but there were various witnesses that supposedly or allegedly had seen the assault carried out. Now, of the 8 employees, 5 of the employees settled the matter. And so when it came to the Labour Court, there were only 3 employees from the original 8 that the matter was still in dispute. And so the matter that the allegations against these 3 employees was that they had witnessed the assault but not brought it to the company's attention. And on that basis, they were charged with dishonesty. In addition to that, there were 2 employees for which the company had provided a second allegation of misconduct, which was that they had failed to provide them with the PINs to their company-issued mobile phones, and therefore this had an impact on their investigation process. Now, in front of the CCMA, the commissioner decided that the key aspect before it was whether or not the company could take disciplinary action against these employees, considering that the matter had occurred after working hours and away from the premises of the company. And to this extent, the commissioner found that the incident had occurred had nothing to do with the business of the company. Its key finding in this regard was as follows. It said that focusing on the charge of dishonesty leveled against these applicants, the evidence before me showed that the employee was indeed assaulted on the day in question. Evidence on that was lengthy. However, the incident occurred outside the working hours and during the applicant's time. Those who witnessed the incident might have failed to disclose same. However, there was no obligation to report the incident to the company. As stated above, there was no link between the incident and the respondent's operations. There was also no evidence led showing a link between the incident in question and the respondent's vehicle that was at the premises. So in essence, the CCMA found that there was an insufficient nexus between the assault that got carried out and the company's operations. The court then looked at that finding, and they applied the established principle that applies to employers for off-duty misconduct and said that employers generally have no authority to discipline employees for conduct that occurs outside working hours and away from the workplace unless the conduct is sufficiently connected to the workplace. To this extent, they cited the well-known cases Horn versus Biersnaar and others, as well as other related authorities. And they confirmed that essentially it's a factual inquiry into the factors, and that this requires, one, that one looks at the nature of the misconduct, 2, the relationship between the employee and the victim, and then whether the conduct destroyed or seriously damaged the employment relationship. In this case, the court found that the social gathering was voluntarily attended, organized by employees rather than the company, and was not connected to the company's business activities. And for that basis, it said that the employer was not entitled to take disciplinary action under these circumstances. So it said that it found that the nexus was not sufficiently close for the company to take disciplinary action. And on that basis, it found that there was no reason to interfere with the finding of the commissioner. The second aspect of it is quite interesting because, as we know, often when investigations are carried out, employers may be required to access the company-issued devices to employees. And so in this instance, what happened was that the employees were asked to provide their mobile phones to the employer, and they said that they provided the phones, and then when they were asked to issue the PIN for the employer to access the phones, they refused firstly to provide it, and then would pretend that they couldn't remember the PIN. And so they were then disciplined on this basis, and they said that the company issued an allegation against them saying that they weren't assisting in this regard, and therefore disciplinary action should be taken in that regard. The court then considered this aspect as well. So the first thing they said was that in any event, because the matter was not sufficiently connected as off-duty misconduct, that on that basis alone, this allegation should not be considered. The court then also said that should they be wrong in that regard, in any event, there are certain principles that one needed to apply. So the first thing it does is it looks at the policies that were applicable. And interestingly, the company had a policy which provided that at any point, the company may need to access the data on the phone. And under those circumstances, the employee would be required to provide details. But the commissioner and the court then dealt with it on a different basis. They said that as much as those policies allowed for that, there was no policy which prohibited private use of the cell phones. And under these circumstances, it would have been unreasonable for the employees to have to provide the phones if, firstly, they're not told why they need to provide the phones, and secondly, one has to take into account their right to privacy and allow them at least to remove any personal information from the phones. So that's quite an interesting finding from the court. And I think that under these circumstances, potentially the employer may have been able to deal with the matter slightly differently, and that may have given rise to some of the issues. I think both in the way that they obtained the phones or sought to obtain the phones and access it, but also in the notice of allegations. But it's quite an interesting finding that the employer here, or the court found that the employer should have respected the employees' rights to personal information contained in their phones, and that before handing over their phones, the employer may have certain obligations in that regard. So on that basis, they found that the court also stated that because of the way that it was dealt with by the company, the employees should not have been found guilty of this allegation and should not have been dismissed. So I'm mindful of time. I'm going to conclude there. Thank you, Roz.
Thanks so much, Louay. Okay, Sibusiso Dube is our next speaker, and he is going to speak to us about the last two cases for this morning. The first case is also one about off-duty misconduct, where the court examines the nexus between the off-duty misconduct, or the need for a nexus between the off-duty misconduct and the workplace. And then the last case for the morning will be really examining what constitutes or whether the conduct that occurs in this case constitutes discrimination in circumstances where employees are engaged in a protected strike. Over to you, Spoo.
Thanks, Roz, and good morning to everyone. So the first case that I'll be looking at is the case of Imatu on behalf of Sauls versus City of Cape Town. So the brief facts of this case is that Mr. Sauls was employed by the City of Cape Town as a learner law enforcement officer. What happened was, on a particular day, whilst he was off duty, he was stopped, and it was found that he was driving whilst under the influence of alcohol. So when he was stopped by the SAPS members, he then proceeded to tell them that, he was one of them, and that if they did arrest him, they would be arresting one of their own. He was subsequently arrested, and he was then disciplined. The charges against him, the first charge was that he had been arrested. The first charge was that he had been arrested for driving under the influence whilst off duty. And the second charge was the fact that he had told the officers that they were arresting one of their own. And so the City of Cape Town charged him with bringing the City of Cape Town into disrepute. Now, regarding the criminal charges against him, he did not acquire a criminal record, and instead, he was required to undergo a diversion program. And so that was the outcome of the criminal proceedings against him. Now, in the disciplinary hearing, he was found guilty of both the allegations against him. On the charge of bringing the City of Cape Town into disrepute, he was issued with a warning. And then on the charge of being arrested for driving while under the influence, he was dismissed. He was obviously not satisfied with this outcome, and he took the matter to the bargaining council. Now, at the bargaining council, his main issue was that the sanction against him was too harsh, and that there had been an arbitration award for similar circumstances relating to another officer, where the arbitrator had found that the dismissal under those circumstances is unfair, and that the City of Cape Town had not taken that award on review. The arbitrator found that his dismissal was substantively fair, and he then took the matter on review to the Labour Court. Now, before the Labour Court, the main issues that the court had to consider was whether a sufficient nexus existed between his off-duty conduct and his employment relationship, which is similar to the case that Louis has just spoken about, whether the sanction of dismissal was appropriate in the circumstances, and whether the commissioner had erred in his analysis by considering irrelevant aggravating factors. Now, what the court then found in this case was that the commissioner had committed quite a number of errors, which rendered the award reviewable. First, the court found that the commissioner had improperly conflated issues relating to the second charge, which he was found not guilty of. So that was issues around how the applicant had actually behaved himself, or rather his conduct, while he was being arrested. So the commissioner considered the applicant's behavior while he was being arrested, which was linked to the second charge, in reaching his outcome. And so the court felt that this was an error by the commissioner, and that the commissioner was only required to consider the allegations pertaining to charge one. Secondly, the court also found that the commissioner had speculated and made findings that were without evidence, in particular, that because the applicant had been arrested for driving under the influence, it was likely that he would also drive under the influence during working hours. So that was complete speculation by the commissioner. The court also found that the commissioner had failed to properly apply the considerations in various case law, in particular that the commissioner had not considered that regarding the criminal charge, that was not viewed as being serious by the criminal justice system because he was only required to undergo the diversion program and that there was no criminal record flowing from that, that there was no victim, there was no impact on the workforce or employment relationship. The incident had occurred off duty and only the applicant's passenger was present. So it wasn't something that was in full view of the public. So the court found that the commissioner had erroneously concluded that the nexus existed solely by virtue of the fact that the applicant was a learner enforcement officer. The court also looked at the fact that there was a previous arbitration award which had not been taken on review, and the court concluded that because that arbitration award was not taken on review, this was not in circumstances that were actually worse, because the employee in that case was of a senior level and the blood alcohol percentage or the blood alcohol level was higher for them compared to this employee. So the court concluded that by not taking that award on review, this was not conduct that the employer actually considered as being serious. And ultimately, the arbitration award was then set aside. This is very interesting for me in that you have a law enforcement, I'll say intern, who is arrested for breaking the law in circumstances where his job is to ensure the upholding of the law. But the Labour Court found that, look, that's not enough to justify a dismissal under the circumstances. I'm quite interested to see whether or not this will be taken on appeal. So that was that case. Then the second case that I'll be looking into is Solidarity on behalf of Arendse versus Heineken Beverages. Again, another Labour Court case. Now, the focus of this case is whether or not Heineken breached the provisions of Section 5.1 and 5.2 of the Labour Relations Act. And I think it's important that I just read the relevant sections out for us so that we understand the context within which this case was brought to court. So Section 5.1 of the LRA, protection of employees and persons seeking employment. No person may discriminate against an employee for exercising any right conferred by this Act. Without limiting the general protection conferred by subsection 1, no person may do or threaten to do any of the following. And subsection C says, prejudice an employee or a person seeking employment because of past, present, or anticipated exercise of any right conferred by this Act or participation in any proceedings in terms of this Act. So this dispute arises as a result of Heineken's failure to pay a short-term incentive bonus to Solidarity members who had participated in a protected strike. Now, Heineken has this STI policy, which provides that the company may decide to grant or not to grant an STI payment or bonus under certain circumstances. So, for example, if there is poor performance, a resignation, or participation in industrial action, then that may disqualify you from participating or from being granted this STI payment. So what happened in this case is Solidarity sought certain organizational rights, which Heineken did not want to grant to them. They then, they went through the process. A strike certificate was issued and they gave notice of the strike. When they gave notice of the strike, Heineken informed its employees that anyone who participates in that strike, one, they will not be paid for not coming to work, so the no work, no pay principle will apply. But secondly, that participation in the strike could impact one's ability, or rather could impact one's entitlement to the STI that may be payable later in the year. So of course, when the time came around June, the strike was in February, then around June, the time came and Heineken declared that it would be paying out an STI bonus to those employees who qualified. And seemingly, the members of Solidarity who had participated in the strike, they were not paid. And so they then brought this case to the Labour Court on the ground that they had been discriminated against and that Heineken's conduct was in contravention of the sections that I had read, because the only reason why they did not receive this benefit, or rather this bonus, is because of their participation in the protected strike. And that by having the policy stipulation along these lines, it actually interfered with Solidarity's ability to perform its functions as a union, and also these members of Solidarity to actually participate in industrial action. So there's quite a number of cases that the court considered in reaching an outcome, but ultimately the court considered two LAC judgments. The first LAC judgment was that of Safco Freight versus SA Freight and Dock Workers Union. And ultimately, in this case, the principle that was held by the court is that Section 5 of the LRA requires the conduct to be unjustifiable because it is irrational, lacking in proportionality, unreasonable, or actuated by improper or illegitimate motives. The second case that the court considered, which was a more recent LAC judgment, and it really just pronounced and gave some color to the first LAC judgment that I've just mentioned now, was the case of National Union of Mine Workers versus Cullinan. Now, in this case, again, the employer in this case had decided that it was only going to make a certain payment to employees who had worked during a strike as an incentive, and to pay them and thank them for the work that they had put in during a difficult period when other employees were striking. And because they had actually worked, they had assisted the company in being profitable and ensuring that there was enough production in that period to ensure that they are able to shut down over the December period. So those employees who had worked were then incentivized for working during the strike. So that's what that case was really about. And in determining this matter, the court found that in the Cullinan case, it was found that the measures must be suitable and necessary for the purpose. So if the employer can justify that the incentive is a proportional way to achieve a legitimate collective bargaining aim, then the discrimination will not be unfair. So, and I'll just read a portion from the case. It said that if an employer can withhold the benefits from strikers and correspondingly offering it to non-strikers, despite the fact that this amounts to discriminating between the treatment of strikers and non-strikers, if the employer can justify it as a way of discouraging strikers from engaging in strike action and encouraging employees to choose to work, this is an acceptable part of collective bargaining power play tactics, provided that it is a suitable and proportional way to achieve that aim. If those criteria are satisfied, the differential treatment of strikers and non-strikers will not amount to a breach of Section 5 of the LRA. An employer needs to do more than simply say it adopted the strategy as part of collective bargaining power play. Now, those are the principles that the court considered in the Cullinan case. And in the present case, the court found that, yes, whilst an employer may differentiate between striking employees and non-striking employees, Heineken had failed to demonstrate how the loss of this STI bonus was a proportionate measure to deter strike action, particularly given that the strike only lasted 2 days and it was only supported by the employees of, the members of Solidarity, which is a minority union. Heineken's implementation of this policy was not in response to the strike. They had warned the employees beforehand that if you do go on strike, you will not get, it is likely that you will not receive your STI bonus. So Heineken provided no details of the impact that the denial of the bonus would have on strikers or on the impact of incentivizing workers not to strike. So there was just no explanation from Heineken why this was proportionate, to completely deny the bonus, especially in circumstances where the strike ended after 2 days. So even though in the Cullinan case, the conduct was found to be fair, in the Heineken case, the court has found that the conduct was not fair and that Heineken had not provided an adequate defense to justify the withholding of the STI bonus. And so Heineken's conduct was found to be in breach of sections 5.1 and sections 5.2C6 of the LRA. Thanks, Ross.
Thanks so much, Sbu. Well, thank you to everyone. I think that wraps us up for the morning. Thank you for joining us, and thank you to our panel for what I think has been a very interesting morning. I hope everyone has a great day, and when we reach the weekend, a lovely weekend. Keep well, everyone. Bye.